Hello, everybody. Welcome back to the Conduct Detrimental Podcast. I'm your co-host, Dan Worley. I'm joined by a European currently, Dan Wallach. Dan, how's London?
Oh man, much better than being in Miami. Wow, I definitely dodged the bullet, and it's been enjoyable. I'm going to be in Europe for the next week. Hopefully, South Florida is up and running a week from Saturday, so I'm satisfied out of mind. And one U.S. item that's not out of sight and out of mind is our subject for today, Dan. I mean, this is the biggest story of the year, at least for us. And today, at high noon or 5 p.m., we're going to find out how the judge will rule in the Ezekiel Elliott case, if he rules at all.
Yeah, and I think it's...
So take it away.
I think today is really the turning point of this case. We're going to really see how it's going to go. This is the first crucial day. I think, the hearing the other day was obviously important, but whichever way this goes has a huge bearing on the likelihood of which party wins. I think that the NFLPA has a lot more to lose today. If they don't win today, it's going to be a real uphill battle for them. Where I think the NFL, if they lose today, there's still a few more bites at the apple, especially, kind of like what we saw in Deflategate. They win at the NFL loses at the district court level, and then on appeal, it's kind of like a fresh slate with a panel of judges. But let's get right into the judge's decision today, and I think we'll just give the people what they want. What's your prediction, Dan?
Well, no, I've been kind of shy on Twitter about how I think the judge will rule. First of all, he is not going to put this case to New York, and if he does, we're scratching this bug. He's not even going to put it out on the air. After having held a 2.5-hour hearing on Tuesday, the Judge Mazet spent Labor Day weekend reviewing the briefs, only to have the NFL kick this over to New York and try to file a parallel lawsuit. There's just no way possible that this, and they didn't even mention it to the judge during the Tuesday hearing. This judge is keeping the case, and he's going to rule, and he's going to grant a temporary restraining order or a preliminary injunction in favor of Ezekiel Elliott for the reasons I've outlined ad nauseum, but largely centering on the fundamental fairness ground, which is which addresses the exclusion of the testimony from the accuser, Tiffany Thompson, as well as the notes of the interviews that the NFL conducted with her. That goes to the crux of the case and the ability to confront and cross-examine your accuser. This is not like Deflategate where we're talking about competitive edge in a football game. This is almost like a quasi-criminal proceeding, and not having the accuser in that arbitration is tantamount to a deprivation of fundamental fairness.
Yeah, and I think, we've seen the NFL's arguments against this point, and they say, and I'm going to lump Harold Henderson in with the NFL at this point, but they, basically come out and say, well, listen, we can rely on these other court decisions. I have unwielding power, but at a certain point, there's certain things along the way, and I think you outlined a few of them. And to me, the most important point was not as much not having the accuser in the arbitration hearing. You can see why there may be an excuse for that. Apparently, the NFL's never done that, but why deprive them of the interview notes? That decision just made absolutely no sense to me on any level, and I think that really strikes a chord on being an actual fundamentally unfair process. And from what we've heard coming out of some of the folks who were in the courtroom the other day, it sounded to me like the judge in this case had a real problem with some of these issues. What's your read on that, Dan?
I mean, it's almost like Judge Richard Berman from the Southern District of New York, did some mind meld with Judge Amos Mazat, because some of the questioning of the NFL's lawyers on the issue of fundamental fairness echoed almost the exact line of questioning that Judge Berman used in the Southern District case 2 years ago in Deflategate. I think the judge has already tipped his hand. We don't have the transcript, but several people in attendance, just took just extensive notes, and there seems to be a general consensus that the judge was much more difficult on the league's attorneys and focused on the fundamental fairness issue, as I have written about and as you've alluded to. I think not having the notes is certainly I think it's the turning point. I mean, you can't compel Ms. Thompson to come into another jurisdiction, but the NFL didn't even ask. And she cooperated with the NFL throughout the investigative process. She probably traveled to New York at the league's expense. The league never even bothered to ask her to participate in this proceeding because they didn't want her there. But not having her present, the next best thing were these interview notes, and depriving Elliott of these interview notes, I think will end up sealing the deal and results in a temporary restraining order or an injunction being granted in favor of Elliott, which is not the end of the case. Obviously, we still have, the full merits of the district court case. But, as you and I both know as litigators, the decision on a motion for a TRO or a motion for PI generally presages the ultimate result at the district court level, because if the judge thinks it's likely that one party is going to succeed, barring any new evidence, that result will hold in the final judgment, and there won't be any new evidence here. The real question, and there are two questions, is what would the Fifth Circuit do? Will the Fifth Circuit treat this issue any differently than the Second Circuit did in Deflategate? And more importantly, from a strategy perspective, is it in the judge's best interest to maybe issue a TRO but not a preliminary injunction, and then cycle up or expedite the final hearing on the merits and rule within the next 2-3 weeks? Because a TRO is not appealable to the Fifth Circuit, so the judge might be able to exercise some dominion and control over this lawsuit, because once he issues a PI, it's just going to go right away to the Fifth Circuit, and he could stand a chance of getting reversed, although I don't think he will be in this case.
Yeah, I just want to highlight a couple of points that you went over pretty quickly, and one of them is literally what goes into the decision making for a judge when issuing a TRO or PI, and that's, like you said, the likelihood of success on the merits. So essentially the judge is saying, I think, if he grants it, he's saying, I think that Ezekiel Elliott is eventually going to win this case. And so that's why this is such a huge ruling today, right? Yeah. We're in a position where the judge is basically going to come out and say, unless something dramatic happens later on, that this party is going to win or that party is going to win. And I think, to me, and I haven't seen the transcript as well, but the irreparable harm issue, which is the other major point where there was Elliott was irreparably harmed, but that has sort of fallen off. I think that's sort of a given at this point that he is irreparably harmed. So now we're really focusing on this likelihood of success on the merits issue. And so whether it goes the NFL ways or the PA's way is going to be huge.
Yeah, and I think the standard, at least in the Fifth Circuit, is a substantial likelihood of success on the merits, almost like a blowout. If you're substantially likely to succeed at this stage of the proceedings, what would have to happen between now and the end of the case for the judge to change his mind? So with this decision, the judge is essentially, teeing up the final judgment, which could come, barring an appeal, within a few weeks, or certainly within the next 2 to 3 months, depending upon his, docket congestion. And you'd be a much better law professor than I would. You explain these concepts to the non-lawyers in our audience. I just kind of go right through it and speak in the legal jargon, and sometimes I have to catch myself because I think maybe it might go over the head of those without a law degree. So thanks.
No.
You're picking up the slack for me on that.
You're doing a great job analyzing it. I think all of these things start snowballing, and there's so many different paths that this case could take. Less paths than it's funny. We should probably tell everyone that we recorded a podcast a couple of days ago. We had a technical issue and the audio didn't pick up, and we that podcast, and we had our friend Ian Gunn join us. We evaluated every possible scenario that could happen, and this was before the TRO hearing on I believe that was Wednesday.
We didn't evaluate this, but we didn't evaluate the scenario of the recording not taking.
Yeah, that's the one we missed.
That was
unfortunately.
the one scenario we completely overlooked.
And
sorry, go ahead.
And so, going down all these rabbit holes of different ways things could go based on one decision or the other, you start to realize that there's just so much out there. And so, I just you're doing a great job of analyzing those. I'm just trying to slow us down and make sure that we're all on the same page with what's actually going on. And I think, getting back to, predictions, I think I'm probably more on the fence here than you are. You seem to be, under the opinion that it's definitely going to go Elliott's and the NFLPA's way. I think this is still an uphill battle for the PA. I think that, obviously, and as the NFL has repeatedly hammered their court filings with, there's a lot of precedent out there that leans in their favor. And I think the PA has done a fantastic job of putting some space between this case and Deflategate and really showing the differences. It's just a matter of whether or not the judge in this case is going to buy it. I think there's some factual issues that the PA has overblown, and one of which being kind of these interview notes, which I just said were very important, and they are. But at the same time, if you really dig into the transcript, you'll realize that the arbitration, Kia Roberts testified that the two formal interviews she did of the accuser, she did have notes, and those were turned over. The other ones she didn't deem an interview. They were kind of like follow-up calls or things of that nature, and she didn't turn over notes for those things. So maybe it's a little bit less severe than the PA has made it out to be. Not that makes it right or any more fair, but I think there's certainly some things out there that could give the judge a hook to rule for the NFL or say that the NFLPA doesn't have a likelihood to succeed on the merits. And I think we always have to kind of take the tenor of a hearing with a grain of salt. I think in Deflategate, the two big hearings that we saw, right? So the oral argument at the appeals level and then Judge Berman, those were both predictors of how the courts were going to rule. People that walked out of that, in both situations there, knew and correctly were able to predict how the court was going to rule. Dan, you and I know that's not always the case.
But I think you and I might have been two of the few people who felt that way, because a lot of the commentary coming out of Berman's courtroom for days in all the reporting was the two words, devil's advocate, that it just seemed too good to be true, and maybe Judge Berman was leaning on the NFL a little bit harder to try to force a settlement. I mean, we didn't believe that, but that was the conventional wisdom, and I see traces of the Berman approach in how Judge Mazant questioned the NFL. Again, maybe he's a poker player, maybe he's playing devil's advocate, but I can only go based on the question. I'm not going to start second guessing and thinking it's too good to be true,
yep.
Particularly when there was a very sustained line of cynicism and what I would consider negativity or it wasn't hostility, but it just seemed to be one-sided.
Yeah, I agree, and I think that's the most likely option. I'm just throwing it out there as a possibility that maybe they did have a poker face, and I think there was probably even more of a reason to believe it in Deflategate, because Judge Berman had this stance where I went through some of the documents the other day and some of the docket language, and I forgot about this, but he was constantly pushing the parties to settle. Constantly, everything he would do, he would encourage them to talk about settling the case. We don't have that here. I don't think there's any possibility for settlement. Given the dynamics of the minimum 6-game number in the domestic violence policy, and I said this in our last podcast that no one heard, obviously, but I didn't think there was any chance that Harold Henderson was going to reduce the number. I thought he had two options, either uphold it or vacate it completely. And that's why there's just no grounds to me for settlement. And that being said, I mean, I think the judge hasn't pushed that here, and so maybe there's even more reason to read into the tenor of the courtroom on Wednesday. But as we've discussed, who knows?
Yeah, let's talk about settlement for a second. I mean, I realize that Harold Henderson may have had. I don't think he had a binary, one or the other choice. But the league and the Players Association now have an opportunity to resolve it. to lower the suspension, to pick any number that's going to make sense. But and I agree with you. I don't think the two sides can settle the case. But the reason I believe that is because the NFLPA, the union, I believe it's like a shark that smells blood in the water, and the NFL seriously screwed up with this evidentiary ruling. And of course, we didn't even get into the Keir Roberts, if I'm pronouncing the name correctly, that saga, which shows some kind of a whitewashing of the report and certainly the decision making. I think the NFL, the league, I believe, is vulnerable at this point, given what we've heard coming out of this courtroom. I think there's no way, no how the Players Association settles for anything other than total capitulation, because this is an opportunity to score a major win in court. And if it does get upheld by the Fifth Circuit, that's a counterweight to the Second Circuit and Eighth Circuit decisions. Of course, the PA could lose on appeal, but my perspective on that is they're no worse for wear, because they already have adverse precedent from the two out of two federal circuit courts of appeal. I think this is an opportunity to kind of recalibrate or level the judicial playing field. If the league can score, if the union could score a major victory on a procedural defect in how the league conducts its investigation and how it conducts its arbitration proceeding, I think that could create a valuable precedent for future challenges. And this is the perfect case to use as a test case, given what we've learned.
Yeah, and it would potentially, depending on how the ruling went and depending on what issues are argued in the Fifth Circuit, I mean, it could potentially create some conflicting circuit decisions, which would potentially make this ripe for a Supreme Court ruling as well, which would be just fascinating. We lucked out. We have a sports law case on the Supreme Court docket for this year, the sports gambling case out of New Jersey, which I think we're all looking forward to, I should say.
We hope it's this year.
Yeah,
we don't know that it's going to be this year, but
this year's docket, this next session.
Yeah, it could go into April, but there's always room for more. This is just stuff we love to talk about, and you and I, with our litigation backgrounds, I think we're a little bit more jazzed up when cases go to court, because we can tap into our wheelhouse of litigation experience. We've probably seen and done just about everything you could do in a civil litigation environment. With TROs, motions for preliminary injunction, evidence disputes, discovery disputes, trials. So for me, my antenna go up, and I think I get super excited when these cases, get litigated, as opposed to watching, hoping for some legislative change. This is what it's all about, and
yep.
Having a high-profile case like this that commands the attention of a national audience is exciting.
Absolutely. There's no more exciting litigation than two parties who despise each other too, and I think that's the dynamic that we're in right now. And I found it. We had some sort of ancillary court filings. They're bickering over the content of some briefs that were filed that were allowed by the judge. But anyway, within that, Jeffrey Kessler, the PA's lawyer, as one of the requirements for the filing, they have to do what's called a meet and confer. So they have to, call the other side and say that they tried to resolve this dispute before filing the motion. So I just
in good faith, right? They had to have a good faith conference.
Yep.
Can these parties have a good faith conference?
Yeah, I don't think so. I would have loved to have been a fly on the wall for that conversation. And the funny thing was that there was this paragraph that was quoted from Nash within Kessler's brief. And I just imagine the conversation of being, no, you have to, if you're going to file this, you have to put this paragraph in the brief verbatim. I'm going to type it out. I'm going to send it to you. And I just got a kick out of thinking how that all went down. But in any event, I think it's a good time to talk, and we've touched on this a little bit, but really going through some scenarios and next steps for what's going to happen after today, after it's scheduled to be a ruling come out by the judge by 5. Dan, what happens if the judge grants the TRO but not an injunction?
Well, that's a significant distinction. A temporary restraining order and a preliminary injunction are similar types of relief. They would act as a ban or a prohibition against the league implementing its suspension. But a TRO is only good for 14 days, after which the court would have to have a more full-blown hearing on a preliminary injunction, although the court just did that. But the advantage of a TRO is that it is not immediately appealable. So if the judge issues a TRO, he basically controls the case and doesn't have to worry about the Fifth Circuit interfering in the proceedings, and it would provide the judge with a little bit of leeway to enter a final judgment, meaning after the TRO is entered, the judge would be able to set a briefing schedule on the ultimate relief in the case, which is a motion to vacate the arbitration award from the PA, and competing against that would be a motion to confirm the arbitration award from the National Football League. So he could put it on a fast docket and have the TRO still remain in effect without any appeal right, and then wrap up this case within the next month to 6 weeks. And in fact, I'm surprised that he didn't convert this round of motion papers into a full-blown, decision on the merits. But the league hasn't had an opportunity to answer the complaint yet. The league would need to file an answer. So the judge has a choice. He can either enter the TRO and have it not be appealable, or enter a preliminary injunction, which means that we're going to be in New Orleans beginning on Monday with a Fifth Circuit appeal and the possibility of emergency motion practice before the U.S. Court of Appeals for the Fifth Circuit. So those are the two choices the judge has. And the same holds true whether he grants the relief or denies the relief, because even the denial of a motion for preliminary injunction is appealable. So in the event that the judge, by some miracle, doesn't rule for Ezekiel Elliott and denies the preliminary injunction, I believe that Elliott can take an immediate appeal to the Fifth Circuit and ask for an emergency stay of the suspension. Am I missing anything? Do you agree with that possibility? Not whether it happens, but whether that's even on the table as a prospect.
Yeah, I agree with the whole thing right there. And it's interesting that the judge granting a TRO actually slows this whole case down a little bit. If he goes the PI route, we're going to get a faster route to the Fifth Circuit. I think we're all under the assumption that no matter what happens at this level of court, it's going to be appealed at some point, regardless of which party. So it's just a matter now of which route the judge would like to take at this stage. And if, like you said, if it's just a TRO, we're at least hanging around the district court for the next few weeks. We may have another preliminary injunction hearing in a couple weeks and briefing on that issue, more briefing on that issue. I doubt that they would need more briefing, but it's going to keep it in the district court for longer, which is, if Elliott wins, that's if we're thinking now about going back to his suspension, there's a good chance that the suspension now starts kicking out later and later.
Yeah, but I agree. But what's so weird about this case? Let's compare it to Deflategate. We didn't have any preliminary injunctions or temporary restraining orders at issue in the Deflategate case before Richard Berman. I think Berman just set a briefing schedule for the ultimate relief on the merits, which was a vacator of the arbitration or a confirmation of the arbitration. And the lawsuit was filed in late July, which basically gave the judge a 6-week window to decide the case before the NFL season would intrude on the proceedings. But we didn't have that opportunity here because of the delay in the announcement of the suspension. So it, by necessity, had to go to an emergency, TRO or PI motion practice just to be able to enable Elliott to play for the first week of the season, because had it gone the normal full route on the merits with setting a briefing schedule on the ultimate relief, it would have taken until at least the middle of September, and you'd already be missing a few games. So that is one major distinction between this case and the Brady case.
Absolutely. And it always makes me laugh when people complained about how long Deflategate was taking, because in reality, both Judge Berman and the appellate court in that case both moved quicker than they do in normal cases. They put them on expedited schedules. Typically in litigation, something like that would take probably an extra year, if not longer, to get through. And, the fact, it just kind of gives everyone a glimpse into what, federal litigation is really like. Although that was sort of an anomaly because that moved relatively fast, even though it seemed very slow. And it seemed like it took years for Brady to actually serve his suspension. So do we think a notice of appeal gets filed, today after this, assuming it's an appealable decision?
Yeah, just almost as as a protest or an FU. I think the notion of parties, and we've seen this I know we saw it in the Christie 2 case, the New Jersey sports gambling case. I think we even saw it in Deflategate. The league, and we're in the era of electronic filing. This decision will come down at 6 p.m. Eastern, possibly on a Friday night, but it wouldn't really take too much effort to throw up a 2-pager on Pacer on the docket later this evening with the losing side. If there is a losing side and there is an appealable order, I would expect to see a notice of appeal on the docket later this evening, or certainly by the weekend or Monday. Certainly no later than that. Ordinarily, under court rules, a losing side has 30 days to file a notice of appeal.
Hey, Conduct Detrimental fans, we have some big news to report. We have our first actual sponsor for the podcast. And it's on a topic that's near and dear to our hearts, fantasy football. So if you love fantasy football, then you need to try our new favorite app, Draft. It's weekly fantasy football, but not like the other guys. On Draft, you draft real live snake drafts with other people, just like in your season-long league. Here's how it works. It's a draft that lasts for just 1 week, and there's no management. Just set it and forget it. Once you're done drafting, that's it. No trades, no waiver wire. Draft even takes care of the last-minute injuries for you. Drafts start every couple minutes, so you can join one right now. And the best part, you can play for cold, hard cash. Drafts start at just $1, so there's a draft for everyone. No salary caps, play in a real live snake draft, just like you play with your friends in a season-long league. Come join us on Draft today. Download the app at any time. Just search Draft in your app store and join a game in minutes. Or play right from your computer at playdraft.com, whichever way you want. For a limited time only, all new players get a free entry into Draft when you make your first deposit. But you have to use our promo code, which is SPORTSLAW. That's right, kind of detrimental fans. Play in a real money game for free by just using the promo code SPORTSLAW on your first deposit of the draft. Just search Draft in the App Store or go to playdraft.com and come play with our free promo code SPORTSLAW, and we're back at it. And one other thing, that the NFL did, I shouldn't say completely unrelated, but somewhat unrelated to this case, I guess they rectified one of their big domestic violence mess-ups in the past. And Dan, they came out just today, or maybe last night, and announced that they're suspending former Giants kicker Josh Brown, a subject that we've talked about many times on this podcast, to 6 games, the minimum under the domestic violence policy. He previously had been suspended for 1 game, and then it was an indefinite suspension. What do you make of the timing here?
Well, no, it's certainly no coincidence at all that the league would announce such a suspension within a few hours of Judge Mazzant ruling in Ezekiel Elliott's case. Certainly one of the arguments that the NFLPA has made, will make, is the arbitrary and capricious nature of the discipline as compared with other cases, and the sort of the poster child for all prior cases that that are going to be pointed to is the Josh Brown suspension. Josh Brown violated the domestic violence policy and got only a 1-game suspension. So one possible point of entry, or one possible winning argument for the Players Association would be to sort of point out that disparity, and that it would be arbitrary and capricious to suspend Ezekiel Elliott 6 times as much as Josh Brown. So I think maybe the cynic in me But I mean, the guy hasn't been in the league for almost a full year. The last time he kicked, I think Pete Gogolak was still in the league. I mean, he's gone and forgotten. Why is it taking the league a full calendar year to rectify that, and no less on the day of the Ezekiel Elliott decision? I mean, it could have waited until Monday. I doubt that there's any innocent explanation for this, because the optics should have been obvious even to the National Football League.
Yeah, the length of timing in both investigations has been somewhat questionable. I think we saw a little bit behind the curtain in the Elliott case, that what took so long, and they had all these experts in, which I think elongated the timeline. I think what's interesting about Josh Brown, other than just the timing of the decision, is what the PA is going to do about it. Are they going to have? Is there going to be another appeal? Is there going to be another federal lawsuit? I mean, these are possibilities at this point. I think it's going to come down to, in part, what happens in the Elliott case, and they're going to start being on parallel timelines here. I'm assuming that they're at least going to appeal on the NFL level, based on sort of a double penalty, if not other errors on the NFL's part. You know, if you didn't get it right the first time, how can you just punish us again based on a public opinion? Dan, we've seen that argument before in the Ray Rice case, obviously operating under a different policy at the time, but still a very curious timing for that decision. And also, I just can't imagine that I don't know, maybe I'm pessimistic and think that the NFL always looks at things through a PR microscope, but there's a lot of not great cases floating around the news lines right now. But we'll see. I mean, opening weekend, I'm sure the games are going to, override that, but we'll see.
Yeah, I mean, my perspective on it is I don't think Judge Bazant is going to fall for it. First of all, the comparison and the different penalties, I don't think it's such a big argument anymore under the new domestic violence policy if it's 6 games. This case, the Elliott case, is going to turn on the procedural defects rather than the extent of the punishment, I believe. And I'll for once try not to advance the litigation cause. I don't think Josh Brown is going to challenge this. He wants to play in the league. What is he going to get from fighting it? He's going to get 5 weeks money. He's unemployed right now. He's not earning. I don't know what deal he made with the Giants to, what kind of severance arrangement, but I think his contract isn't guaranteed. He's out of the league, and if he fights the NFL, he'll remain out of the league for the foreseeable future. You don't have to fight the NFL in court to be blackballed, as Colin Kaepernick knows all too well. So I think Brown accepts this punishment, and perhaps once he finishes serving it, which he's probably already served it, it might provide a more palatable environment for Brown to re-enter the league, because no longer will he have gotten away with it. He will have served the full suspension. And if Ezekiel Elliott can come back and play in the National Football League after presumably physically, assaulting somebody, and we don't know if that's true. We certainly don't know if that's true, but if he can come back and participate in the league following this alleged conduct, then why can't Josh Brown? And I think the outcry over Brown, just like the outcry over Ray Rice, came not from the offense itself, but from the NFL's under-punishment of the offense, which ended up getting foisted on the player as the fallout. So I think Brown accepts it, and maybe he'll play in the league again. He's too good of a kicker, but unfortunately, for him, kickers are probably the most fungible, position in the league. But tell that to the team that loses a playoff game because of missed extra points. So he'll be back in the league at some point, and this longer suspension will create the right PR environment for it.
I disagree. I think he's toxic. I think he's done. I think kickers are a dime a dozen. I don't think there's any argument that Elliott's going to be back in the league. He's obviously one of the best football players in the NFL. I think every team, there's always the risk versus talent balance that teams have to make. And for a kicker, if Josh Brown makes one more field goal a year than Robbie Gould, is he worth taking on all of that PR negativity and, potentially alienating some of your fans? I think the answer for all the teams is no, personally. For Elliott,
you might be right. You might be right. We're
yeah.
talking about a kicker. We're not talking about a quarterback.
Right. I can't remember Josh Brown's exact age, but I know he's been around for a while, so I think he was sort of the tail end of his career anyway. But for Elliott, there's no doubt he'll be back.
There's no tail end of a career.
That's true.
And, Morton Anderson, I think is he still kicking? I mean, their life cycle for a career is like a quarter of a century if they're any good.
It's a good point. Good point. Noted.
Yeah.
And apparently for quarterbacks now, although Tom Brady didn't look so great last night, but I think that was someone else. But anyway, I think there's one more point that we wanted to roll back on that we probably glazed over too quickly before, and that's related to today's hearing. We talked a lot about the likelihood of success on the merits, but the other big issue here is irreparable harm. And, Dan, I think we were talking earlier about, do people really understand what irreparable harm means? And usually from a legal sense, this is generalizing it, but it's something that can't be made up for by money. So you can't just pay for them. And I think, you look at it from the outside and you say, hey, Ezekiel Elliott, even if he misses these games and they rule for him later, he can get the money back. But that's not really what it is it, Dan?
No. In fact, in some jurisdictions, there's two separate requirements that are related to harm. That you would have to show that the harm would be irreparable, and then you would have to also show the inadequacy of money damages, meaning that if you're seeking a preliminary injunction, but you could be compensated, if you could be made whole through the payment of money, then you don't get the injunction. Here in the Fifth Circuit and under the federal standards, irreparable harm is not equated with you can't be compensated by money. It's a different. It's kind of difficult to describe, but the defense that let's say if Elliott were placed on the exempt list and got every paycheck that he otherwise would have missed for 6 weeks, well, that would not prevent him from being irreparably harmed because it's loss of playing time. It's the intangible associated with an athlete's short playing career, the opportunity to keep pace with your colleagues, to be able to practice, to be able to earn honors, to help your team win. None of that can be compensated by a paycheck. So I think if you eliminate the possibility that he could be made whole through money as a factor, because it is not a factor on the irreparable harm prong, at least not in this case, I think if you eliminate that element from it, it's a no-brainer that a professional athlete who misses significant playing time, no matter what his age, will suffer irreparable harm because the lifespan of an athlete is going to be short, whether he's in his 20s or 30s. It's not like being an accountant or an engineer or a lawyer, although those professions don't necessarily have a lot of job security. But I think the federal court decisions almost uniformly recognize an athlete's loss of significant playing time as tantamount, not just tantamount, but actually as irreparable harm. So I think it's one that you can immediately and automatically check the box for Ezekiel Elliott here.
Yeah, and I think one of the fascinating, interesting facts about this case was that we saw the head lawyer for the Dallas Cowboys, the general counsel, file an affidavit on Elliott's behalf, essentially saying that losing him would be irreparable harm to the team. In their pursuit for winning a Super Bowl, making the playoffs, and those are all. I mean, it was fascinating to me to see the team kind of go out on a limb for a player who has been accused of things that are not pretty. And I know that throughout the whole process, we've talked about this before. Jerry Jones is obviously very much behind his player. But for the lawyer to do this, I'm curious as to how that conversation went with between the owner and the GC of the Cowboys. But we'll never know those things. All right, Dan. Well, we hit we're about 10 minutes longer than we were supposed to go, but that's okay. I'm glad we were able to put this together, and I'm sure we'll have a lot to talk about in this case moving forward. It's far from over, in my opinion. No matter what happens today.
I think this case becomes our weekly episode for the rest of the year. It'll be like the roots of sports law.
Yeah.
And, we could just do a version on it every single week, especially if the judge issues an order that's appealable. Because if it's appealable, then that changes, it just changes the venue and begins a whole new set of questions anew. If it's just a TRO, then we're going to have kind of a holding pattern for at least a couple of weeks. So I look forward to 2017 being the year of Ezekiel Elliott and the year of Daniel Worley and Daniel Wallach. So it's a great way to start the season.
Absolutely. We'll have a great time in London, Dan, and we'll be back soon. Thanks, everyone, for checking in. Subscribe on iTunes, leave us a review, and we'll talk to you next time.